Welcome to the First District Court of Appeal. We have one case on the docket today. It's Classy Cycles Incorporated versus Panama City Beach. I see that both counsel are present. Counsel for the appellants, you may proceed when you're ready.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
So noted.
My name is George T. Reeves. I represent the appellant, Classy Cycles. With me at council table is Mr. Mark Murray. Classy Cycles is challenging two ordinances of Panama City Beach. Ordinance 1415 prohibits my clients and others who rent out scooters from renting them overnight. Ordinance number 1416 completely prohibits the business of renting out scooters as of September 8, 2020. In all parts of Panama City Beach, it will be completely prohibited September 8, 2020. Now, these ordinances, based upon their whereas clauses, their recitals, plainly say that the reason the ordinances were enacted was because the city council viewed the way that the drivers of the rented scooters, the way they operated those scooters, the city viewed was too reckless and dangerous and irresponsible, and so the city enacted the ordinances. Now, and we don't think there's any dispute on that. That's plainly from the whereas clauses. Now, in Classy Cycles versus Bay County, this court ruled that the city of Panama City Beach, as well as Bay County, was not allowed to directly regulate the operation of scooters. This court ruled that those ordinances where they attempted to do that were preempted and had to be stricken.
Now, how do these ordinances relate to the operation of the scooters as opposed to the offering, which seems to be the threshold
Absolutely.
issues in the briefs?
Well, in Alachua County versus Lewis Oil, which both briefs cite as Lewis Oil 3, in that case, this court said that where a local government is preempted from directly regulating an activity, they are also preempted from indirectly regulating
But
the
in that
activity.
case, it was specifically language that the statute had to be approved, or the ordinance had to be approved by the Department of Environmental Protection.
Yes, sir.
Doesn't that make it a little bit different here?
No, Your Honor, because in our case, it says it's expressly preempted. In that case, it was expressly preempted unless approved by DER, and in that case, DER did not approve it, so that puts us in the
It
exact
looked like Judge
same.
Fenson's order here treated this as a zoning ordinance.
Yes.
Basically, he said, this is a zoning ordinance, maybe it is, maybe it isn't. Do you take issue that if this was truly a zoning ordinance, that the city could accomplish this? Do you understand my question? It's truly a zoning ordinance.
Yes.
I know you don't think it is. You think it's a regulation of the use of motorcycles or motor scooters.
Right.
But does the city have the power under home rule to specifically exclude certain types of activities from certain areas?
I think there's two answers to that. Number one is they do not have the power through zoning or anything else to indirectly regulated activities that are preempted. That was specifically addressed in the Attorney General opinion that was cited also, where the Attorney General gave the opinion where the city of Mulberry wanted to prohibit certain businesses through its zoning code that use radioactive substances. The Attorney General said, no, that's expressly preempted, the use of radioactive substances. You can't, through your zoning code, go in and eliminate those businesses because they use radioactive substances. They're going to be liable they're going to be under all the other zoning codes.
Well, that was a citing statute, though.
Sir, I'm sorry.
Wasn't that a citing statute, if I remember correctly? It's like the prison citing statute. You can't rezone this out. Those statutes specifically say you can't zone out this activity.
In the city of Mulberry, the statute was a statute under Chapter 404, not dealing with land use, that said that local governments may not regulate the transportation or use of radioactive substances. And what the Attorney General said is you can't then, through your zoning powers, eliminate businesses because they use radioactive substances, because you don't get to regulate that.
Well, isn't there, okay, this is going to go back. I used to represent a small city
Certainly.
that was pretty much residential. There wasn't any commercial activity in the town. If they had passed an ordinance prohibiting the regulation or any commercial activity within the town, would they have the right to do that?
There is authority that, I think there's no Florida Supreme Court authority, but there's, I believe, a second DCA case and a fourth DCA case that approved that, where they had small residential towns that were outside of big employment cities, and they said, we don't want any commercial activity, we don't want any industrial activity. That's not this case. In this case, the city has picked out a specific business, not all activity, and they have said because we are preempted from regulating the operation, we are eliminating that one business, not all commercial activity. The problem here is not that they can't zone and they can't regulate their land use. The problem is they can't use zoning as an indirect method to regulate what they're not allowed to regulate directly. That was the holding of
Okay,
Lewis Oil.
I'm going to keep on pushing here. The
Certainly.
zoning, is zoning a reasonable method of relieving congestion in certain areas of the city?
It may or it may not be, Judge. The problem here, though, is that's not what they did.
I understand.
Okay.
I mean, I'm kind of going along the lines of Judge Fenson's order.
Yeah.
The city, the Panama City Beach is not a very big city.
Correct. Well, it's not big space-wise. I mean, it's
Well,
big
that's
if
what I
you're,
mean, yeah.
if you're talking about the amount of the budget and all that, yeah, it's a fairly
Yeah.
big city.
No, but I'm talking about the
Size.
size-wise. And if we have an overly congested city, shouldn't the city be able to regulate activities that are going to cause more congestion or more problems?
They might, I can't say that they can't do that, Judge, that they can't use their land use powers to regulate congestion. That's not what they did here, though. It's not about congestion. What they're doing here is they're saying we want to regulate the operation of motor vehicles. Since we can't, we're going to totally prohibit the renting out of scooters. Since we can't do what this court said we can't do in Classy Cycles versus Bay County, we're going to totally prohibit renting out of scooters. That's the whole problem, and that's what this court said no to in Lewis Oil. In Lewis Oil, the specific quote was, and remember in Lewis Oil, there's three cases. Lewis Oil 1, they overturned the ordinances dealing with where the county had added regulations to underground petroleum storage tanks. Lewis Oil 2 was approving the temporary injunction.
Okay,
Okay.
I understand your preemption argument regulating, but haven't I just undercut your argument that the city can only prohibit something if it's a nuisance by my questions that I just talked to you about? I mean, you have conceded that through zoning powers, the city can say no commercial activity, none of this. So the city, if they have a rational basis under zoning, can prohibit certain activities from the city, can they not?
I think through their zoning powers, they can choose which broad class of activity they would like to have in their city, and they can exclude certain broad activities. The problem is, though, with the Carter case and the Inglis case that I've cited in the brief, both of those cases say that it is arbitrary to try to exclude a particular use. In Carter, they picked surfing, where they said we are just simply prohibiting surfing from the town of Palm Beach. The Florida
Okay,
Supreme
the
Court
Carter
said you
case
can't do
was
it.
pre-Home Rule Powers Act.
Absolutely it was. And the one thing Home Rule does not do is Home Rule doesn't say, cities, you are now welcome to enact arbitrary ordinances. Carter.
No, I agree with you.
Okay.
I mean, I'm just trying to figure out what the scope of our arguments are here. So
Okay.
in order for you to win on that last thing, you have to show this is an arbitrary and unreasonable ordinance.
No, Your Honor, we do not.
What, on that last count,
No, Your Honor, we do not.
why not?
Because what Carter and Inglis said is, if the activity is not a nuisance per se, by law, an ordinance completely excluding it from the city is arbitrary.
But the Home Rule Powers Act says the city can do anything that the legislature can do.
Absolutely, and thanks to opposing counsel, they've cited you a case, the Landrum case, where the Florida Supreme Court overturned a statute for that very same basis. The Florida Supreme Court in Landrum said that a statute which sought to limit the authority or the ability of insurance adjusters to advertise, they said that was arbitrary, and they struck the statute, Judge. Arbitrary is no more proper in a statute than it is an ordinance. We don't think Home Rule.
I understand that, but
Okay.
I'm just trying to find out what the test is here.
The-
You said a city could not regulate. Your argument at one point was the city could not regulate out of business unless it's a nuisance.
They-
And I'm challenging you on that
It-
because I'm saying the test only test that I'm aware of, after the Home Rule Powers Act especially, is whether an ordinance is arbitrary. Putting aside preemption and conflict.
Absolutely.
So the test is no longer whether it's a nuisance, the test is whether the regulation that the city is enacting is unreasonable and arbitrary.
Right.
And
So-
if it is unreasonable and arbitrary, I agree with you.
Right.
Like, that's due process.
Absolutely. Now, assume, and just to clarify, let's assume Chapter 316's been repealed, right? Assume that's been repealed, no preemption argument. At that point, the ordinance, if it's arbitrary and unreasonable, is not allowable. It's not allowable before municipal home rule, not allowable afterwards. The Carter and the Inglis case say, if the activity you're seeking to totally exclude from your city is not a nuisance per se, that ordinance is arbitrary. That's the holding of the case. And the reason we know that is, in Carter, the 4th DCA had a bunch of evidence. They cited evidence. They cited the testimony from the city manager saying surfing's horrible. Surfing hits people in the head with surfboards, all that kind of stuff. The Supreme Court, looking at that evidence, reversed the 4th DCA and said, this is not a nuisance per se. It's not a nuisance at all time, at all places, in all circumstances.
Okay, I'm going to switch you, Mr. Reeves, with the panel chief is going to let me, and I'm sure she'll give you more time if you need it.
Oh, okay.
I know you got hit with the supplemental authority, which should have been filed earlier than it was, with the new statute. Are you prepared to address how the new statute affects this case?
Okay, the supplemental authority had 6 things. It had 2 newspaper articles, which
I
we
don't care about the
object.
newspaper articles.
Okay.
I don't care about what the newspapers say. I don't care about the other ordinances.
Right.
None of that to me is relevant. The
Okay.
only thing that was relevant in that supplemental authority that was filed
Right. And I think,
was the new statute.
and I think you're talking about chapter 2019-109, Laws of Florida, which was the second thing. And yes, we're ready to address that. Specifically, Judge, what I would cite to the court on that statute on page 2 in section 3, 316.2128, that statute takes these micro-mobility devices and says they are now going to be considered a bicycle, which is a vehicle that is governed under chapter 316. Then it goes in and adds a new sentence that says, however, this section may not be construed to prevent a local government through the exercise of its powers under 316.008 from adopting ordinances governing the operation, et cetera. So what this statute does is it says motorized vehicles are now bicycles. They are therefore covered under 316. Then this statute creates an exception to what we believe to be is the preemption given by chapter 316, and what we believe this court ruled was the preemption. You can't, in Class C cycles, it said you cannot regulate the operation of motor vehicles. If Class C cycles, if that wasn't true, why do you need this second sentence in 316.2128(1)?
Okay, let me follow up on that, because it talks about still having the powers to regulate under 316.008.
Right.
And nobody specifically pointed to subsection N of that statute in the briefs, I don't think.
Okay.
Subsection N says, these are the things that a city can do. Prohibiting or regulating the use of heavily traveled streets by any class or kind of traffic found to be incompatible with normal and safe movement of traffic.
Okay.
And obviously, that generally goes to trucks, keeping trucks
Sure.
out of the...
Heavy vehicles, all that.
Why couldn't that not apply in this case as well? Because the city's argument, I'm going to make the city's argument, it doesn't mean it's my
Absolutely.
argument, that the class of traffic here, whole city of Panama City Beach is heavily traveled. So arguably, they could say no trucks because, it's not incompatible. Why couldn't they say that what the uses here are incompatible with normal and safe movement of traffic?
Okay. The reason is this, and just as you said, no one cited that statute, so this is my horseback.
I know, but I had an awful time that I read statutes and
I
stuff
know,
that
I
people
know.
don't cite.
But this is the problem. What they're talking about here is the whereas clauses and the recitals in this ordinance do not support that fitting under there. That is talking about where just the regular operation of vehicles creates problems. These heavy trucks and all of this create problems coming through. That's not what they're trying to get at. What they're trying to get at is they're talking about the operation of these scooters. They're saying the operation of these scooters is dangerous and irresponsible, et cetera, and that's why they've got to get rid of them. So that's why it doesn't apply. And also, Judge, let's assume for a moment that there are, well, we don't have to assume, like we just talked about in zoning. They can have a zoning code that says this area over here is residential, and our business couldn't locate there any more than anybody else. That's a neutral ordinance. The problem here is they're trying to get back to the operation of the scooters, even if they use their legitimate powers. But the point is to get to things they are preempted from regulating. That's going to be a preempted ordinance. They're not allowed to indirectly regulate what they are preempted from regulating directly, even if it were through legitimate means. And I'm not confessing that would be a legitimate means, but that's my response on that statute.
If they didn't phase out these devices, but they just had the first restriction, what would be your response to that?
Well, in our number one, remember we've got two arguments. One's preemption, one's the Carter and Inglis cases. On preemption, it's the exact same argument. They can't eliminate them, they can't restrict them because they want to get at the direct regulation of operation.
And if they've passed an ordinance that said, hey, we've got an island community, we only have a couple main thoroughfares and side streets are very narrow, so we're going to ban certain types of transportation devices or certain types of vehicles during certain hours.
Yeah.
Okay. Well, they could do that certainly.
They may well be able to do that for reasons other than the reasons they were prohibited from enacting ordinances under Classy Cycles versus Bay County. They might be able to do that. We'd have to approach that ordinance when we got it. Even if that were a legitimate way to enact an ordinance, you can't use your legitimate powers to get at something that you're preempted from regulating directly. So that would be on the preemption aspect of it. Now, on the other aspect of it, on the Carter and Inglis not only bar complete prohibitions of an activity, they also bar regulations that are in substance are prohibitions because they are so onerous. In our initial brief, what we've asked for is that if you did decide based on Carter and Inglis to reverse, that would need to go back down. The trial judge would need to decide whether or not the overnight restriction was so onerous and burdensome that it would be a complete prohibition. Our clients are saying it's that big of a deal in the rental of these scooters. And so we would have to go show that in front of the trial judge. Where this case came up was on summary judgment. We weren't given that opportunity. We were ruled against at summary judgment.
Okay, if there's no further questions, now I will extend your time by 4 minutes to give you an opportunity to rebut. Of course, your time will be extended as well.
May it please the court, Cole Davis, along with Amy Myers and Julia Madalena of Hand, Arundel, Harrison, Sale on behalf of the city of Panama City Beach. There are two issues in this case. The fundamental one is what is the scope of 316's preemption? And to respond to some of the argument that was just made, this argument that there is some indirect regulation of vehicles is simply not true.
Well, let me ask you a question. Could the city pass an ordinance saying because of the heavy crowded streets that we have, we restrict, rather than all this stuff about rental, we restrict the use of these vehicles during these hours?
Now, what I would say is that's a question of interpretation of that exemption. I certainly agree that we could do that. That's not what we did here, based upon the fact that this is purely...
Answer the question, though. Could you do that?
I believe we could, yes.
Would that be allowed?
I believe we could, and I will remind the court that you can affirm this for any reason.
Tell me why that is not essentially what you're doing. I mean, requiring they be returned before 7 o'clock in the evening. I mean, effectively what you're doing in this ordinance, in your whereas clauses, is saying we don't want people using these motor scooters between 7 in the evening and 7 in the morning on our streets.
Right. And the whereas clauses, I think, are only illustrative if you have some question about the actual body of the ordinance itself, the actual regulation. The regulation is very simple. The body of the ordinance itself is very simple. What it did is it discontinued grandfathered use of motor scooter rentals in the land development code as a zoning ordinance. It also regulated the rental as a business regulation in our code of ordinances. Now, both of those are purely commercial ordinances. They're purely commercial regulations. And to
What is the rational basis for doing that, other than keeping motor scooters off the street from 7 in the evening to 7 in the morning?
Well, that's honestly a great question, because, so we're a resort town. We are a tourist community. We are wholly funded almost by a 1% business license tax. And so Panama City Beach is in and of itself similar to almost Disney World, that it caters to its guests. And the city council found that the guests don't like these, that overall, the community doesn't like them, the guests don't like them, and kind of the same way that other towns prohibited all commercial uses, the city council determined that this is inconsistent with the identity of our city now. And so what they did in 2015 is prohibited that land use under their zoning code. There's a motor scooter rental use category in our zoning code, 2015, now that's not challenged on appeal, but these were already prohibited under the zoning code. Now, the ordinances that are challenged today simply amortize that non-conforming use out to end the grandfathering. So that is the rational basis right there, and it's in the whereas clauses we cited in our brief. Of course, this was in response to Class E1. We don't dispute that. This was in response to the fact that you can't separate the wheat from the chaff. The experience itself to our guests and our residents was of paramount importance to the city, and that's why they decided to make
But
this
is it
ordinance.
rental business what upsets your visitors, or is it the use of the cycles that upset your visitors?
Well, again, you can regulate the commerce regardless. And let me point out to you an example that the appellant cites in their brief, which is the Solomon versus Miami case. That case, they cite to prove that you cannot indirectly regulate something, and the court in that case said that case was about a business license tax based upon the number of vehicles you had in your business. And the court said you can't charge a business license tax based on the number of vehicles you have, but you can charge a business license tax based upon the fact that you're doing business in the city. There's a difference between regulating a business and regulating a vehicle. And to be perfectly honest, the city learned its lesson. And to distinguish Class E1, what you had there is you had this language in 316.007, which says you cannot concurrently regulate on a matter covered by 316.
But isn't it the case that these have to be returned by 7, so you're effectively regulating the use of them on your streets? Because if I rent one, let's say I happen to get up early one morning and rent one, I've got to get it back to the business location by 7, and it has to be off the street by then.
The city will not do anything to you if you keep that scooter longer. This does not affect the operation whatsoever. It doesn't affect the vehicle whatsoever. If you rent a scooter in Panama City Beach and you drive it wherever you want at midnight, you're not going to be subject to any penalty whatsoever by the city.
That's not how I read it.
Well, if you want to look at the code, hold on, let me just look.
It can't be a rental scooter, though, because the rental scooter has to be,
The business cannot rent the scooter, and the contract has to require that the scooter be returned. But the operator himself, he or she, is not subject to any sort of sanction whatsoever by the city. There's no penalty by the city on the operation of the scooter.
Well, I thought you just said I could be on my scooter at midnight.
In the city's case, absolutely. The city's not going to pull you over.
So you're going to sanction the business.
Correct. For entering into the contract.
Which in turn will sanction the customer in some regard,
Well,
a late fee or whatever the case may be.
that's up to the business. I mean, obviously, the city can't regulate the entire chain of commerce from, the stalk of wheat to the loaf of bread. But at the same time, if we regulate grocery stores, we're not regulating every single thing that's in that grocery store. We're not regulating the use of every single thing that's in that grocery store. If we regulate a pharmacy, we're not regulating those drugs that are in that pharmacy.
okay, let's say we kind of buy your argument that this is a legitimate business regulation. Why doesn't it become a question of fact whether it's arbitrary and unreasonable, precluding summary judgment?
Well, primarily because the appellant didn't raise that issue. And we pointed out in our brief where they had an amended complaint that asserted that this was an arbitrary and unreasonable regulation. And then in their amended complaint, they scrapped that line and argued specifically that if it can be whatever it is, it can be whatever, the facts can be whatever they are, and as long as it's not a nuisance per se, we can't prohibit it. That's the end of the discussion. If they had raised an issue of that this is an arbitrary and capricious regulation under substantive due process. We would have had that debate, we would have had that before in the lower court. But that's not what's been raised here. And so that's not what was litigated. And we cite in our brief multiple times where we pointed that out to the trial court, that that has not been pled here, and if it has been pled here, then we have a different analysis to take. Otherwise, obviously, the trial court would have undergone a rational basis argument, and I believe they did a little bit in the order, not based upon the fact that it was pled, but based, I think, in an abundance of caution. But then you look at cases like the Coogan case out of Coral Gables, where they had a regulation that prohibited parking a truck in your driveway, and that was upheld under rational basis standard, and that certainly would violate the appellant's argument. But that's been upheld. And there are many different cases: prohibition of the firing of a BB gun, prohibition of all commercial property in a town. And one thing I want to point out is in one of those towns.
Well, let me think.
Go ahead.
I rent the scooter. I'm out at midnight raising hell on the streets of Panama City. All right.
Correct.
I'm not in trouble, right?
No, you are not.
Okay, so that activity can still go on.
Correct.
But what this ordinance tries to punish is the business who wasn't able to get that person to return it in time.
Correct.
In fact, the person out there could be someone who it's their own motor scooter.
If it's their
They
own
could be
motor scooter,
raising
then
Cain at
the
midnight.
ordinance doesn't apply at all.
Okay, and it doesn't apply to anyone who rents it from one block outside the city limits.
No, Your Honor. And the appellant has businesses outside the city limits where they rent scooters, and they continue to do so, and they are able to continue to do so. And if the appellant wants to rent a
Well,
scooter
then I'm really
outside-
starting to struggle with the rational basis for the ordinance. If you can get around it so easily and have all this congestion on the streets and all that, what are you really regulating?
We're regulating the business as it pertains to the desire of the city council to create a desirable community for our city, for our guests.
But it doesn't, it sounds like if the marketplace works, people are going to put just like they used to do with dog tracks. They put it one block outside of the county limits because one county didn't want the dog track and the other county would let them in. I mean, why aren't you going to have the scooter rentals coming in from one block outside the jurisdiction, or people will buy them?
Well, yeah, I mean, Your Honor, if my
Or
city
what if I make it a
council,
part of the perk of I rent my beach condo down there and I say everyone gets to have the use of one of the 5 motor scooters that comes along with a rental?
right, and if my city council could legislate outside of the city limits, I'm sure it would love to. But at the end of the day, we are regulating the facts as we see them on the ground. We don't have these hypotheticals at play, and if we did, we would have to address them then. But at the end of the day, what the city has done, the city does what all cities do across the state, is regulate the uses they want to see in their communities based upon the identity that they want their community to have. We all have those, and when we look at other similar situations, we have micromobility devices now. We have transportation network companies like Uber and Lyft, where the legislature's come in and said, you can or can't regulate these businesses.
Are they lawful? These scooters are lawful, correct?
They're lawful
Okay,
vehicles.
So your beach clientele say they don't want people smoking cigars, or they don't want people, you come up with some other activity. They want a certain.
Smoking is a very good example. So smoking is preempted. Literally just the term smoking is preempted, regulation of smoking. Now, let's say that a city decides it wants to, because smoking is very hazardous, wants to prevent sales of tobacco products or vaping products within so many miles of a school. Is that a regulation of smoking, or is that a regulation of the sale? That is the distinction we're drawing here, and that's a valid distinction. And the cases bear that out.
I want to turn to the new statute, which was filed in the Notice of Supplemental Authority, and I'm doing so reluctantly because this should have been filed earlier.
I agree, and I
statute has
apologize
been in
to the court
effect for over a
and to opposing
month.
counsel.
Able counsel for the appellant was prepared to discuss it, so it's on the table. So tell us why you think that's important to our analysis.
Well, one of the reasons why we filed it, the complete bill, is because we cite the draft bill in our brief. And the draft bill was actually much more detailed and a little bit more onerous on municipalities because it limited how a municipality could license a micromobility business. Now, what happened in the final version of that bill was any reference really to the sale or anyone offering a micromobility device for rent was scrubbed from the bill, and what was left was the ability to operate the device itself. And what we believe the interpretation of that statute is to mean is that there are certain aspects where cities can regulate micromobility devices. They have to regulate them in the same way that they regulate bicycles, but they can still regulate them. On the other hand, the city can continue to regulate the actual businesses themselves, the programs, and that's why we filed the additional authority. Whether you want to take that under advisement, I totally understand, but.
So you're going to have to ban bicycles now?
Well, these micromobility devices are not the same thing as what the appellant is in the business of renting.
I thought maybe I misheard, but I thought you said they're all in the same category now.
They're not, they're similar businesses, similar business models.
Bicycles are okay in Panama City?
Bicycles are okay.
Okay.
So the new statute explicitly carves out local government's ability to legislate in the area of operation, right? But I thought
Correct.
your argument in the briefing prior to now has been that this really doesn't involve operation, it's the offering.
It does-
So how does
that's
this,
correct.
how does this help you?
It helps because it shows again that the legislature doesn't intend for 316 to cover businesses. It intends for 316 to cover traffic, and there is a distinction. That's how it helps us. When you look at what 316 covers, it's supposed to be the rules of the road. It's supposed to be what's street legal. It is supposed to be to allow uniform traffic throughout our state. Whether I come from Tallahassee into Panama City Beach, I shouldn't have to have a different type of headlight or a different type of vehicle or not be allowed to come into the city. That's the purpose of 316. And every time that the legislature touches 316, we get a new opportunity to look at what that preemption means, because the preemption is fairly vague. It just says traffic and matters covered. So we have two different ways that we can look at this. Under 316.002, we can look at whether this is traffic or whether this is a matter covered. We don't have a matter covered here. And the appellants haven't cited to a matter covered in their briefs or in argument below.
Okay, and the reason you didn't rely on the exemptions in 316.008 is because you don't think 316 even covers this, that you're
Correct.
regulating.
Correct.
So the statute that I cited, 316.008N, has no effect on this case one way or another.
No, Your Honor, but you may have given me some good ideas.
I'm sorry, what?
But you may have given me some good ideas.
I may have given you a good idea, but I'm not sure you used it.
I agree that we did not use it, and we expressly don't use it. We use our power to regulate commerce. And there's a long line of history with these other cases where there's the Avalon Carriage Services case, the Jarrell versus the Bus Lines case, taxis, horse-drawn carriages, whatever they may be, commercial use of public streets. There's a long line of cases that allow that, and some that have very strong language about the city's duty to protect that. And so when we regulate these businesses, it's because these businesses aren't stagnant. They don't sit in one space like a grocery store. But that doesn't mean that when we regulate a grocery store, we're regulating the person who walks out with a loaf of bread.
When you say you've given me a good idea, it gives me a little heartburn, because what I see is your problem, you're not regulating the problem, you're regulating a business to try to get at the problem. And if you have this revelation now that this portion of the statute, which deals with regulating traffic on streets and so forth, this might be a good idea, because that sounds like the real problem. And that the real problem is on the street level, not on the vendor level?
Correct.
So why isn't it, I mean, I'm not trying to second guess your powers. What I'm second guessing is the rational basis for the ordinance to begin with. Like, if you could have done it this other way, clearly under this other provision of the statute, isn't it kind of tortuous to try to put these businesses through the ringer?
Well, Your Honor, number one, I think if we did pass an ordinance under that exemption, we would end up litigating it kind of like we did with Class C1, which was also litigation under whether one of the other exemptions under 008 applied, which was the special condition exception. So, partially, we've already litigated whether an exception applies to these things. Maybe the court is indicating it may have been the wrong exception, but that's not what we did here, and so it's hard to kind of litigate that entire issue at the moment. But I do think there's a rational basis in the whereas clauses as to what the problems are and what the valid reasons for regulating the business themselves are. And when we look at another case that talks about indirect regulation, we look at the Palm Beach County case versus Boca Raton, which is another case where the county created a dispatch service that had all these incentives and all these indications that if you joined their dispatch service and not used your own dispatch service, you would get all these things. And the court in that case dealt with the exact same argument and said, whatever the county hoped to do is one thing, but what the county actually did is an entirely different thing. And in that case, the court said, they have not actually transferred power. They have not taken over these dispatches. The same way, we're not regulating the operation. If you come in, if you acquire a scooter by whatever means you want to, you can operate it all the livelong day in the city of Panama City Beach.
So your position is we can't look at the real purpose that the city passed this ordinance?
You can look at the real purpose, but if the real purpose doesn't also, if the regulatory, the section of the regulation is clear, and it does not actually prohibit the use of
Well,
a
it sounds to
scooter
me
on the
like they're
street.
arguing, I'm not sure you're wrong, that you don't look at the purpose, you look at what the ordinance does rather than the purpose of the ordinance.
And what does it do other than to get these devices off the street? These scooters off the street?
It improves the community experience is what it does. And of course, they hope that it does that. That doesn't mean that it absolutely has to. And that's the test. At the end of the day, that's the legal test. Is what is the actual effect? Are we mandating that you cannot use a motorcycle in the city? That's the question right there. If we're doing it through some indirect means, that's one thing. And we provide the example in our brief where in Class E1, the court said we could not require additional insurance. So if we had enacted a fee that was a victim's fee, and that fee went into a special victims compensation fund, and every single business had to pay a certain amount a month to us, and if there was an accident that was uncompensated, the city out of that fund would pay them. That would be creating insurance indirectly where we can't create insurance directly on these vehicles. And remember that Class E1 specifically said we cannot regulate the operation of the vehicles and the operation, the operator itself by virtue of matters covered under 316, not through some other way. And if you take the argument of the appellant, no regulation of a vehicular business is valid. Whether that's solid waste services, cities have franchises for solid waste services. Those would be regulations of vehicles by virtue of the fact that these are vehicular businesses. I mean, any taxis, again, if you have a franchise agreement that requires certain things, we have these micromobilities now where cities have adopted these pilot programs that put all sorts of different regulations on the business itself, not on the operator. And there is a very big distinction between those two things. And just because we are reacting to one thing doesn't mean that we can't do what we've done now. Any
Thank you,
questions?
Counselor.
Thank you very much.
To try to go back to,
Before you go,
sir,
let me get something straight in my mind, because I just got thrown another curve when they were up there, that this new statute does not apply to these vehicles. Do you agree with that?
the new statute, meaning the micromobility
Yeah.
device, that statute puts those devices, it says they will be considered bicycles under Chapter 316.
No, I understand that, but
Okay.
are the vehicles that are being rented here,
Yes.
vehicles that are covered by the new statute?
No.
Okay, so both sides agree that the new statute does not apply
To scooters, to our motor
to
scooters.
motor, okay, thank you.
Yes, Your Honor.
Before you go too much further, I'm not sure if the time is correct. I had allotted you 4 minutes for rebuttal, and looks like we're at 53 seconds. Are we all set on the time? Okay, thank you. Sorry for the interruption.
Let me catch my breath.
Says that 2:34 is the balance remaining from the 4 minutes. Okay, thank you. You may proceed again.
Let me go back to Judge Wolf's question on the purpose of the ordinance. Let me tell you who did think purpose was very, very important. This court in Lewis Oil. This court said, when it was evaluating that ordinance, it said the purpose and its practical effect was to regulate in the preempted area. Once it recited all of the things that it went through, such as the intent, which was to get at the regulated activity, it concluded by saying the intended and actual effect of the moratorium is therefore to indirectly do what appellant is prohibited from doing directly, enforce standards stricter than the DER standards. Lewis Oil 3 considered intent. It was preeminent in its consideration. It cited it over and over. I also want to go back, Judge, to the Carter case. Carter is a little confusing because of the way it started. Carter started as a county court action. They prohibited surfboards. A guy surfing got a ticket. It went to county court. The county court convicted, took evidence. Is this arbitrary? Yes, or no, it's not. There's county manager testified. These things hit people all the time in the head. We got to prohibit them, Judge. Circuit court overturned the county court. The 4th DCA, in a reported opinion, overturned the circuit court, reinstated the county court, said there was evidence, did just what Your Honor's saying. There's evidence. It was arbitrary. The Supreme Court came in and said, we see there's evidence. You still can't do it. If this activity is not a nuisance per se, it is necessarily arbitrary to completely prohibit it within your city.
Is that then your response to their argument in the brief? I think it was in the answer brief that the arbitrary argument was not presented below.
Yeah, and let me go through that real quick. I didn't necessarily understand that argument, but let me tell you what really did happen. We have always raised Inglis and Carter, and everybody agrees with that, from day one to the initial brief to the reply brief. What happened was, though, we started out arguing that these cases bar these ordinances. In response, at some point below, and properly so, it was proper for them to raise the argument. They raised the argument, well, municipal home rule powers that act has superseded Carter and Inglis. Our response to that argument is, wait a minute, guys, y'all aren't reading Carter and English correctly. They didn't say you lacked legislative authority to enact the ordinances. They said an ordinance that totally prohibits something that is a nuisance that is not a nuisance per se is necessarily arbitrary. And that's how that argument went. We've always argued that Inglis and Carter prohibited these ordinances. The part that kind of evolved through there is when they raised municipal home rule powers. Our argument is Carter and Inglis are based on arbitrariness of the ordinance. Municipal home rule power doesn't affect the ability of a local government to have an arbitrary ordinance. It couldn't before municipal home rule powers. It can after.
Okay, Councilman. Is there any more questions from the panel?
Well, just
Okay.
let me clarify now. So you're conceding that the Municipal Home Rule Powers Act would allow them to do this, but you're saying they can't do it because it's arbitrary. I mean, that's what I just heard you say.
I sure don't
No,
think
no.
so, Judge.
I-
Okay, look, I'm sorry.
No, because I think what you just said, Carter said this is arbitrary.
Yes,
Municipal Home Rule Powers Act came along.
and did not address arbitrariness.
And what you said was that this, we're not arguing that this may not be within the power of a municipality to do, but what we're arguing is that it's arbitrary.
But our argument, Judge, is municipal home rule powers doesn't affect this at all. In the Florida Supreme Court ruled that ordinances that seek to totally prohibit something that's not a nuisance per se is arbitrary. The Municipal Home Rule Powers Act, the whole point of that, as Your Honor is well aware, was to overturn Dillon's rule and to say when we're trying to decide if a local government, if a municipality has the authority to do something, we don't look and see is there a statute that expressly allows it. We look and see is there a statute that denies it. That has nothing to do with whether or not they're allowed to enact arbitrary ordinances. Municipal home rule didn't affect it.
Okay, thank you, counsel.
Thank you.
Thank you, counsel, as well. Court stands in recess.
All rise.